I'd really like to thank Elena for joining us today, for giving her time. Elena is a health and safety and security partner of the global firm Clyde & Co. She's dual qualified in law and behavioural science, majoring in psychology, which allows her to bring a multidisciplinary and practical approach to supporting clients in managing their legal risks in these very challenging areas. Elena works in both the private and public sectors, investigating and responding to incidents, defending clients in claims and prosecutions, but also in establishing effective safety management systems and processes proactively before things go wrong. Elena advises boards and executive teams on safety due diligence and conducts WHS legal compliance audits, having developed the audit tool, Clyde Comply. So I just, before say hello to Elena, I just want to also say she's also a keynote speaker at the 2019 SIA National Health and Safety Conference on the 21st to the 23rd of May at the International Convention Centre in Sydney. So hopefully we will meet a lot of our audience today there too. So Elena, over to you. Thank you, and very, very big welcome to you.
Fantastic. Thank you so much. Thanks for spending your day, a little bit of your day before the Easter break with me to talk about industrial manslaughter. And unless you've been living under a rock, you would have heard about the craze for industrial manslaughter reforms currently sweeping the nation. So industrial manslaughter coming soon to a jurisdiction near you, and I'm going to give you all of the developments as of pretty much today in this space in Australia. Now, the introduction of industrial manslaughter laws in Queensland in October 2017 really put the renewed campaign for industrial manslaughter back on the agenda around the country. And whatever it is that we think of the need for industrial manslaughter offences and whether they are fit for purpose as the solution for the problem that they are said to be solving, it really is a reality with which industry just simply needs to grapple now. So I wanted to give you a bit of a sense of where we're heading in the agenda today. I really want to focus on the current state of play in terms of regulation on industrial manslaughter around the country. I then want to talk about the potential reforms ahead, particularly in light of the recommendations of the Boland Review into the model WHS laws. And I also want to talk about how these developments connect to the broader trend of individual criminal prosecutions in the general criminal laws arising from health and safety, working environment type incidents. And then what those developments mean for organisations operating around the country, and also give you some practical tips for how we should be responding to these developments. So a bit of an agenda for us over the next hour. So let's get into it. First things first. State of the nation. It all started with Queensland, as I said earlier in the latest round of industrial manslaughter campaigning. So Queensland went rogue after the Dreamworld fatalities, and to a certain extent also the Eagle Farm fatalities. When you have a problem that potentially includes the level of regulatory enforcement, one of the oldest political tricks in the book is to show a sign of strength and add a tough new provision to demonstrate, look, practically here we are, we're taking action. So Tim Lyons was asked to do a review of Queensland's WHS laws, but was told in doing that review that he had to make recommendations for industrial manslaughter. So it was no great surprise to us that his review ultimately did make such recommendations. Now, when you look around the country, the introduction of industrial manslaughter laws is taking on a heavily political flavour, with Labor governments and Labor oppositions all committed to the cause. So important to note that it's been in the ACT for a long time. So it was introduced in 2004 after the Royal Canberra Hospital implosion incident that killed one person and injured 9 others. But how many prosecutions have we seen in the ACT since the introduction of industrial manslaughter laws as part of the General Crimes Act down in the ACT? Well, that would be none, exactly none. Interestingly, the ACT government, in its submission to the 2018 Federal Senate inquiry into industrial deaths in Australia, actually suggested that if a model industrial manslaughter offence were to be introduced, it should be modelled on the Queensland offence. And I'm going to come back to talking about that a little bit later. Now, with the Labor government in Victoria re-elected in November last year, they're following through on their promise of consultation ahead of the introduction of industrial manslaughter in that state. So we've got a new workplace safety ministerial portfolio created, overseeing a special reference group to consult with families on the drafting of an industrial manslaughter offence. And I'm going to talk a little bit more on the current form of that proposed offence a little later. Now, WA has said it intends to introduce an industrial manslaughter offence with 20 years jail time for acting recklessly, which is different to the Queensland offence of acting negligently. Now, WA's favourite thing to do, I find, is announce an intention to do something on health and safety laws without actually getting around to doing it. So I'm a bit of a wait-and-see kind of girl when it comes to WA. Now, the NT has recently conducted a review into its WHS laws by the same guy who did that Queensland review. So Tim Lyons was asked to consider a gross negligence test for any industrial manslaughter laws, similar to that in Queensland, and I'll come back to his recommendations a bit later. In South Australia, at the March 2018 election, Labor promised industrial manslaughter offences but lost the election, so it's not likely to occur under this particular government. And it's a similar position for Tasmania. In New South Wales, the Labor opposition before the election came out and said they were committed to creating an industrial manslaughter offence, but as we all know, they lost the 23 March 2019 state election, so we're unlikely to see it introduced in New South Wales anytime soon. Now, in late 2018, the Federal Senate Standing Committee on Education and Employment looked into the framework for the prevention, investigation and prosecution of industrial deaths in Australia. And the committee recommended the introduction of national industrial manslaughter offences. And specifically, the committee recommended that the model WHS laws be amended to include an industrial manslaughter offence modelled on the Queensland provisions. To incorporate this into Victoria and WA, which as we all know have not implemented the model WHS laws, the committee was recommending the continued pursuit of that harmonisation agenda across the country. And the committee was persuaded that such offences were necessary, particularly for those corporations that are willfully flaunting WHS laws and whose negligent actions result in catastrophic outcomes, and those corporations who are repeat offenders, quite particularly. Now, the current federal government response to the Senate inquiry noted that particular recommendation and made some observations on why the federal government takes the view that the current laws cover the field. And that included the view that current general criminal laws basically cover the field when it comes to manslaughter. And they also made a particular point of saying that the industrial manslaughter offences in the ACT have not resulted in any prosecutions. It was interesting because in the evidence that the ACT Work Safety Commissioner gave to the Federal Senate inquiry, he stated that the ACT provisions being tied to the employment relationship, which is a pre-model WHS laws approach to organisational duty holders. So with the concept of a person conducting a business or undertaking rather than the employer being the primary duty holder under the WHS laws, he really took the view that there was a need for the ACT to come more in line with what the model WHS laws do, and an idea that an industrial manslaughter offence would more properly live in the model WHS laws rather than in the Crimes Act in the ACT. Now, the current federal government's view is that current criminal manslaughter laws are able to address workplace deaths, provided that those provisions are appropriately applied. If Labor wins the next federal election on 23 May 2019, I think there'll be considerable pressure on a Labor federal government to follow the lead of the various state Labor governments around the country on industrial manslaughter. I don't know if everyone caught up with this development, but last year the ACTU Congress 2018 expressly agreed a motion, kill a worker, go to jail, industrial manslaughter. And that's long been a project of the union movement. One of the great ironies, I think, is that the union movement appears to want personal jail time type of accountability for the notion of, big bosses. But the reality is, with the way that the industrial manslaughter offences have been introduced in Queensland, for example, we are kind of seeing that it might be likely that you see lower level supervisory type workers also being taken in terms of that sort of site management type workers that might have more in common with workers on the ground rather than the big bosses in boardrooms around Australia. And I'll return to that idea later. but that's particularly given some of those definitional aspects of the current Queensland provisions using the phraseology of senior officer rather than officer under the model WHS laws. So I'll return to that a bit later. So that's a bit of a sense of the state of the nation of where things are at around the various jurisdictions as they stand right now. So we've had a lot of recent developments in the last few months in terms of reviews looking at industrial manslaughter offences. So I wanted to talk a little bit about what has been coming out of those recent developments. So first things first, the Boland review being released in early 2019. Mari Boland did the National WHS Laws review, and that report has been delivered to Safe Work Australia December last year and released in February. And on industrial manslaughter, the report recommended the creation of an industrial manslaughter offence to be integrated into the model WHS laws. And the report recommended that the offence be drafted such that it can be committed by either a PCBU or an officer for conduct that is grossly negligent in causing the death of an individual to whom a duty is owed. Where corporations are involved, the conduct engaged in on their behalf and that of their employees, agents and officers would also be attributed to the corporation. The recommendation fell short of proposing specific penalties, but did recommend that in drafting the offence, consideration be given toward the overall need to increase WHS penalty levels, which was subject of a different recommendation, and the development of sentencing guidelines for courts to support consistency in sentencing outcomes, which is one of the other issues that we have seen since the introduction of the model WHS laws. Now, in recommending an approach that differed to the Queensland provisions, the Boland report considered that the Queensland offence falls short of targeting organisational as well as individual aspects of corporate conduct. And Mari Boland really does share the view that we at Clyde & Co have previously expressed in our discussion paper on industrial manslaughter, that the Queensland offence reference to senior officers rather than officers as defined under the WHS laws really has the potential to introduce a layer of confusion. While the offence applies only to the death of workers and not other persons as well, is meaning that that expanded scope of the duty of care is not aligned in how these industrial manslaughter offences have been introduced in Queensland. So in terms of what's happening next with the Boland review, the Model Laws Review report is going through a regulatory impact process this year before the nation's WHS ministers respond to the report, and we understand that's going to occur later in 2019. So we probably won't see clarity on the harmonised position with respect to industrial manslaughter until very, very late this year, and probably more likely into 2020. Now, Victoria and Northern Territory, as mentioned earlier, further consideration towards the introduction of industrial manslaughter offences in Victoria and the Northern Territory. And these approaches also differ slightly from the reforms in Queensland and the recommendations under the Boland review. So in the Northern Territory, the Lyons review recommended a similar industrial manslaughter offence to that in Queensland, and the review recommended that two separate criminal offences be inserted into the Northern Territory WHS Act for senior officers and employers whose conduct negligently or recklessly causes the death of a worker. So it's quite interesting because it's quite close to the current ACT provisions in there being a recklessness and a negligence type of test, and you can choose which one is appropriate to the conduct in question. And that would require the standard of criminal negligence being applied, resulting in penalties up to $10 million for corporations and life imprisonment for individuals, rather than the 20 years sort of jail time that we're seeing elsewhere in other provisions and other proposals. So it's almost a hybrid, I would say, of the existing ACT and Queensland approaches. And in Victoria, the current proposal of the government is for an offence where either the employer's or the individual's negligent conduct causes the death of a worker, supplier, contractor, routine maintenance workers, visitors, or a member of the public. It's unclear whether an individual will be defined to include both officers and employees. But one would expect so. Similarly, it's proposed that a standard of criminal negligence is applied with penalties of up to $16 million for corporations and up to 20 years imprisonment for individuals. So I guess my question for you now is, are you exhausted yet? There's quite a lot going on in this space, a lot of people looking at this separately, and a lot of individual jurisdictional differences emerging, which is causing quite a bit of grief in terms of the harmonisation project here as well. Now, given that everyone seems to be using the Queensland provisions as some sort of reference point or indeed a template for industrial manslaughter offences around the country, I thought it's probably a good idea for us to ask the question, are the Queensland industrial manslaughter offences really a good idea? And I've previously expressed the view that I think they represent the rise of a solution that's not fit for purpose. And I've got 5 major problems with industrial manslaughter as a reform as it's currently in terms of those Queensland offences. So I think they interfere with the objectives of and the risk-based preventative framework established by health and safety laws. Secondly, they further entrench the myth that existing health and safety offences are somehow quasi-criminal in nature and not real crime. And that indeed is further undermining the entire health and safety laws in terms of their key objectives. Thirdly, when they're introduced on a jurisdiction by jurisdiction basis in the way that we're seeing with different tests, different standards, different offences, different levels of penalties, they're posing a threat to that general proposition at law that the law should apply to all people equally. And we have the potential for less consistent outcomes because we've also got multiple potential offences at play in the context of fatal incidents that occur during the course of work. And also, just because an offence is on the statute books doesn't mean that it's going to be used in enforcement action or that the penalties imposed by the courts will be consistent with community standards. So that's kind of my sense of why I don't think these laws are the appropriate way forward. But I'm much heartened by the fact that Mari Boland's review has pretty expressly dealt with quite a lot of those criticisms in the recommendations that she has made for the way forward in terms of how you would do harmonised industrial manslaughter offences. And I'll talk through the way in which she tried to deal with some of those things as we look at the Queensland provisions. But I think it's a good time to actually look at the Queensland industrial manslaughter offences. So those offences attract a maximum penalty of $10 million for organisations, 20 years imprisonment for individuals. That's quite some headline. It really gets your attention. But really the thing that's worse is that those reforms sitting within the WHS laws as they do and how they're interacting with the balance of the legislative regime. So I want to explore that with you. Basically, we've got a provision that's now commenced that says if a worker dies at work and a PCBU was negligent in relation to that death, they are liable in relation to an industrial manslaughter offence, attracting that maximum penalty that I've described. Now, the standard we're talking about here is criminal negligence. I'm reading that as criminal negligence. We're probably talking about what we'd call gross negligence. So then the question becomes, how does that differ from recklessness? If I were to suggest which is probably more serious between negligence and recklessness, I would be guessing recklessness. Now let's step out the actual elements of the offence under the Queensland industrial manslaughter offence. The prosecutor needs to establish that the worker died in the course of carrying out work for the accused, or indeed later died from injuries suffered in the course of carrying out work for the accused. The accused conduct caused the death, and the accused was negligent about causing the death of the worker. Now, for criminal negligence, you need that proof of conduct that falls so far short of the reasonable person standard, the care a reasonable person would be expected to take in the circumstances, that it warrants criminal punishment. Recklessness requires a prosecutor to prove foresight on the part of the offender that the conduct engaged in would probably have the consequences that another person at the workplace was placed or could be placed in danger of serious injury, and that the offender displayed indifference as to whether or not those consequences would occur. So which is the worst type of conduct to you? Why is the choice of negligence rather than recklessness in the Queensland industrial manslaughter provisions interesting? Well, for me, it's interesting because in Queensland, you've still got the Category 1 offences under the duty of care provisions, and Category 1 requires recklessness, and that attracts 5 years imprisonment and a $3 million penalty. So what's remarkable is this. It seems to me that in relation to the Category 1 offences, you have a more serious offence on the legislative books with a lesser fine, but requiring a higher standard in addition to this new industrial manslaughter offence. So it's a pretty perverse position. We have higher penalties for a lower standard of offence under the same law. Now, Mari Boland has tried to deal with that particular criticism in her review report recommendations. And she's recommended that the Category 1 offence be amended to have a threshold of gross negligence in exposing an individual to a risk of serious harm or death. Now, this would align with the report's recommendation that a standard of gross negligence be adopted for the model industrial manslaughter offences. As for what Boland considered the standard of gross negligence to be, the review stated that gross negligence requires proof of such a great falling short of the standard of care which a reasonable man would have exercised, and which involved such a high risk that death or grievous bodily harm would follow, that the doing of the act merited criminal punishment. Very similar to the definition I gave you a little earlier. Now, in providing that definition for gross negligence, the Boland review is really citing High Court of Australia authority in a couple of cases there. So I think we are likely to see that kind of a definition coming through. Boland also recommended that the penalties under the model WHS laws be amended to reflect increases in both CPI and the value of penalty units, with the scales of penalties to be reviewed on an ongoing basis as part of harmonised laws review processes. Now, this would result in a significant increase to the Category 1 offence penalties. And one would imagine that the penalty thresholds established by Queensland and soon to be Victoria in relation to the industrial manslaughter offences in those jurisdictions would be considered relevant to any further work on increasing Category 1 maximum penalties under the model WHS laws. And if that's the approach adopted, I think that would go some way to alleviating some of the concerns that I have, certainly around the consistency within the WHS legislative framework itself when it comes to industrial manslaughter offences. But with the Queensland provisions, the farce continues. In addition to the anomalies I've already talked about, we also have this definitional issue introduced in the legislation around the persons who are liable for these types of offences. So you've got this idea of senior officers being reintroduced in Queensland as opposed to officers as defined generally in the model WHS laws. And the senior officer definition is really harking back to the old legislative drafting in Queensland laws to be a person concerned in the management of a corporation. Now, you might say that that sounds similar to what an officer is for the purpose of the model WHS laws, but unfortunately there's a whole body of case law that would disagree with that assertion. The definition of an officer for the purposes of the duty of officers under Section 27 of the model WHS laws is the same definition in Section 9 of the Corporations Law. So we're talking really about that part of the definition that says a person who makes or participates in making decisions that affect the whole or a substantial part of the business of the corporation. And that has long been held to be a narrower set of persons than persons concerned in the management, because that used to be the test under the Corporations Law. And there's a whole body of case law interpreting that definition in the context of corporations law that says the test is different. The new group is narrower and the old test is a broader group of people. So follow the argument. A broader set of individuals in Queensland are liable in relation to a 20-year imprisonment term, and a narrower set are liable in relation to a 5-year imprisonment term. Does that make sense to you? It seems to be a bit of an issue there. Now, as I mentioned earlier, Boland Review considered that issue when formulating the recommendations on industrial manslaughter, and actually did say that it considered the reintroduction of the senior officer concept in Queensland as having the potential to give a rise to a layer of confusion, especially given that that definition of senior officer includes a reference to executive officer. And this was the reason why the Boland report recommended that a model industrial manslaughter offence should apply only to officers as already captured by the Section 27 officer duty. So in relation to the existing provisions, another thing to be aware of is that to be guilty of the traditional offences under the primary duty of care, you've got a time limitation period. You've got 2 years in most jurisdictions, including Queensland, with extensions of time for coronial inquest findings, for instance, as well. WA has a 3-year time limitation period. And the difficulty in Queensland in relation to the industrial manslaughter offences is that there is no time limitation period for taking these sorts of charges forward. So basically, if you have a fatality in Queensland, you're waiting to hear potentially forever. Now, that's great news for lawyers, not so much for people in organisations, because it means you never get closure. Now, the reality is the broader criminal law manslaughter offences operate in the same way. And the chances are, if no one's come knocking up after a reasonable period of time, it may not be an issue for you. But it's something to keep in mind. And it's been interesting to see the industrial manslaughter offence developments in the context of the model WHS laws, including that Category 1 offence for reckless conduct, attracting $3 million penalties and $600,000 and up to 5 years potential jail time for officers and $300,000 and or 5 years imprisonment for other individuals such as workers. So quick recap on what the Category 1 offences under the Model WHS Act are. Those offences occur if 1, the person has a work health and safety duty, 2, the person without reasonable excuse engages in conduct that exposes an individual to whom a duty is owed to a risk of death or serious injury or illness, and 3, the person is reckless as to the risk. So you see, the entire point of those Category 1 offences under the Model WHS laws was contemplating the same type of conduct being captured in those industrial manslaughter provisions. They were there essentially for the same purpose. So lawyers like myself were wondering, why do we need these industrial manslaughter provisions in the first place? And I think part of the answer really is that the difficulty we've had is that we simply haven't seen that much enforcement action using the Category 1 offences since the introduction of the Model WHS laws around the country post-2012. And we've only just started to see Category 1 prosecutions being successfully completed in the courts. So I thought I'd tell you a little bit about those. How many Category 1 prosecutions have we seen successfully completed? Well, we have 2 against organisations, 1 in New South Wales, 1 in Queensland, and 1 against an individual in Queensland, the same related case to the organisational one. So the organisation prosecution in New South Wales was the Kadar wine products case in 2018. And we also had just earlier this year, February 2019, Gary Lavin and Multi-Rum Roofing in the Queensland Maroochydore Magistrates Court being prosecuted for Category 1 offences successfully. And in fact, the officer there seeing some jail time of one of 2 individuals, of the first individuals to go to jail under health and safety laws anywhere in the country. So Victoria being the other one, we saw the existing provision for reckless conduct causing death in Section 32 of the OHS Act in Victoria being used when a waste operator, Maria Jackson, was sent to jail in relation to conduct involving a forklift late last year as well. So, you know, if we're thinking about the fact that the Model WHS laws have been in place in many jurisdictions since 2012, we're now 6-7 years later and we've literally seen 2-3 successful Category 1 prosecutions. It's no wonder that people say that things are not working, but it might not be a problem of the provisions, and it might be more of an issue in relation to regulatory enforcement. None of the Category 1 charges arising from the Eagle Farm racecourse double fatality in October 2016 proceeded to trial, with either guilty pleas being entered for the lesser Category 2 offences, or indeed general criminal law manslaughter charges being pressed instead in relation to the conduct of Claudio D'Alessandro in relation to that double fatality. So we've also got cases currently before the ACT courts that include Category 1 offences in relation to a fatality at the University of Canberra Hospital, but it will potentially be a number of years before we see the outcomes in those cases. So up until these 2018, 2019 cases, there were other Category 1 offences, prosecutions commenced only to be withdrawn, and you'll remember a couple of these high-profile cases. And by way of example, early false starts included cases against Schwing Australia and a New South Wales engineer arising from the tragic 2012 death of 21-year-old Ben Contantaridi in the ACT, who was killed when a faulty concrete pump boom collapsed on him at a construction site at the Kingston foreshore. Now, Schwing and that individual were responsible for maintaining the concrete pump that collapsed, but the charges against them were withdrawn by the DPP following the introduction of new expert evidence on the cause of the plant failure itself, finding that the failure of the bolts was not due to incorrect tightening during the maintenance process, but rather due to a metallurgical phenomenon called hydrogen embrittlement. So the headlines at the time when those cases were withdrawn didn't focus on the actual cause of the incident and the plant faults, so much as the idea that there were no consequences for companies or individuals resulting from this tragic loss of life of a 21-year-old worker during work. And as his distraught mother, Kay, said at the time, there's no accountability and justice. Ben is just another statistic. And I talk about that because I think it's really important contextual background for the reforms here. This call for industrial manslaughter offences really occurs because of that very real desire on the part of those directly impacted by workplace fatalities, for there to be real consequences for individuals and companies when someone dies needlessly at work. And in that unimaginable grief, I'm not sure that people understand that there may be actually negative consequences for safety and for safety culture in shifting the discussion away from a proactive health and safety risk management-based regime towards one that has more of a focus on penalties due to consequence, based purely on outcome. And I'll return to that later when I talk about what the developments really mean for companies and individuals. So these industrial manslaughter provisions come about in that broader political context of community expectations. And in fact, I think community expectations for corporate conduct is something that we're seeing more broadly in the public debate. And in fact, our industrial manslaughter reforms here have almost been a precursor to that broader discussion happening about corporate conduct with things like the Royal Commission into the banking industry. So we've really been ahead on that front. I should also note that there's a flurry of prosecutions by police in relation to what are otherwise considered health and safety type offences, and not least of which we've got Eagle Farm, which I've already spoken about, but also a very active interest we saw from police in Dreamworld as well. And Queensland's long said that they want their industrial manslaughter reforms to be captured nationally as part of the review into the model WHS laws, and I do think you know, that is kind of borne through in the consideration that Mari Boland gave that during the National WHS laws review. She took into account submissions of the Federal Department of Jobs and Small Business, the ACT government submission to the 2018 Federal Send Inquiry, the Queensland Alliance review, and indeed our industrial manslaughter report and the National Review original recommendations back in 2008, 2009 in making her recommendations on industrial manslaughter. So I think we are going to see even more developments over the next couple of years in this area. But I can only hope that if the regulatory impact process and WHS ministers of the states and territories ultimately approve industrial manslaughter offences, that some of those kinks in the Queensland provisions are sorted out through that process. All right, I've mentioned we're starting to see police getting involved in the sphere of influence of the health and safety specialist regulator. And I think it's really important to understand just how much that is a national kind of trend. So we've got Queensland currently with 2 such prosecutions ongoing in relation to Eagle Farm racecourse fatalities in October 2016. The construction manager on the site has been charged with 2 counts of general manslaughter under the criminal laws, following the death of 2 workers crushed by a 14-tonne precast concrete wall in a foul water drainage tank that was under construction at that site. And that case is currently before the Queensland Supreme Court. The second arises from a fatality at a Springfield Lakes construction site, where an excavator operator has been charged with manslaughter under the general criminal laws after his excavator hit a worker in the head in April 2017. There's another ongoing manslaughter prosecution in the ACT. The prosecution arises from the collapse of a crane being used to move an 11-tonne generator at the University of Canberra Hospital construction site in August 2016. And the crane driver is alleged to have overridden the overload alarm on the crane and continuing with a lift which was over the crane's design capabilities. And the crane driver is being prosecuted with manslaughter charges, while there are also separately a number of Category 1 and Category 2 charges under the WHS laws against a number of PCBUs involved, their officers and the crane dogman. The thing I find really interesting about that case is that the ACT does have industrial manslaughter provisions, and yet that crane driver allegation is in relation to the general manslaughter laws under the Crimes Act. So it's quite interesting, proving that point of just because you have an offence on the books doesn't mean it's necessarily going to be used. If past workplace manslaughter prosecutions are anything to go by, it may be difficult to establish manslaughter in some of those cases. The New South Wales cases that you have on the slide here, the court acquitted Simon Lees and Stuart Lurie of criminal manslaughter charges only last Thursday, so that's hot off the press. These charges arose from a fatal bus crash in the Kangaroo Valley in May 2010 when the brakes on the coach failed. And it was alleged that the bus operator had breached his duty of care by allowing the coach to be used with the knowledge that the brakes were faulty. was also alleged that the inspector signed off on the coach's roadworthiness in breach of his duty of care. And the court wasn't satisfied by the charge beyond reasonable doubt, because we are talking about the standard of reasonable doubt here. In 1997, a Victorian jury acquitted Wayne Lamb in dynamic demolition of manslaughter charges arising from the death of a worker who fell through a ceiling skylight onto the concrete floor below while he was conducting demolition work on the roof. And from a workplace perspective, the prosecution had alleged that the failure to provide a safe system of work was the cause of the worker's death, having failed to ensure that there were appropriate processes in place for covering the skylight. The jury separately convicted both Mr. Lamb and the company in relation to OHS failures, and that failure to provide a safe system of work required by the duty under the OHS Act in Victoria, but acquitted in relation to the manslaughter offences. Criminal manslaughter charges have been more successful in South Australia with a successful prosecution in 2016. So in the Queen and Colbert, the owner of a trucking company was sentenced to 10.5 years imprisonment following the death of a truck driver who in March 2014 crashed into the column of a road sign. The defendant had acknowledged that the truck's brakes were not properly functioning, was aware of it, and had the work be conducted in that truck anyway. So the jury convicted the defendant after finding that their failure to maintain the brakes was such a great falling short of the standard of care that a reasonable person would have exercised, involving such a high risk of death that it merited a criminal punishment. So that heightened police interest in investigating workplace fatalities and indeed commencing proceedings under general criminal laws is something that's going on simultaneously with the safety regulators conducting their enforcement actions under WHS laws. And I think that's a trend that doesn't look like it's going away from my experience in practice. And it needs to be considered alongside the industrial manslaughter developments in relation to what you're doing in terms of your incident protocols. And I'll return to that idea going forward. I don't think this is going to go away just because we have an introduction of industrial manslaughter in general WHS laws. So let's turn to talking about what does this really mean for us? There are a number of questions that we have to ask ourselves here. How do we deal with regulators? Given that we've got multiple regulators having an interest in these sorts of incidents, and you've got the health and safety regulators, you also have the police coming knocking when it comes to a fatality, and in some of these you also have other regulators. For example, environmental regulators might be relevant as well. So we really need to be dealing with all of those complexities whenever we have a workplace fatality in a way that I'm not seeing organisations have necessarily caught up with. The second question that we have here is, well, how do we deal with conflicts of interest between individuals and organisations in this context? Because now that we're seeing multiple regulators taking multiple parties for various proceedings and charges in relation to their conduct as it related to the incident that ultimately occurred, you're actually having multiple interests at play and conflicts of interest developing between them. A lot of these cases are happening on construction sites. As we know, you have a world of contractors and subcontractors involved in that chain. And so you are seeing multiple people being looked at, but we're also seeing the site supervisor, the site manager, the site safety manager, everyone, as well as the officers of the organisations at the boardroom level, all of them being looked at by both safety regulators and potentially police as well in relation to the various charges that may be taken. And that's your general duties, officer duties, worker duties. So we're seeing charges at all of those general WHS law requirements, but we're also seeing the industrial manslaughter overlay of that and potentially general manslaughter overlay with that as well. So how are we managing all of that complexity? It means that the usual approach that we've taken to prosecutions and in fact to dealing with regulators before prosecutions occur, which has been very much open up to the regulators, tell them everything they need to know. The organisation gets lawyers. We don't worry about workers because it's a no-blame kind of environment. That kind of approach really needs to be tweaked in relation to fatalities because there are very, very serious ramifications for individuals across both the WHS laws industrial manslaughter and general criminal laws as well. And we need to be protecting individuals from the second an incident happens against that personal liability piece, and it's not just about officers. So what does that really mean? How do we deal with those conflicts of interest? If there are conflicts of interest between those various interests that come to the fore, well, inevitably it means more lawyers. And if there's one thing I know, when there's more lawyers involved, it's not a good day. What typically happens when lawyers get involved, everyone stops talking to each other, and we have a lack of communication of information. Everyone lawyers up, they draw up the drawbridge, and we stop getting the information that we need about what actually happened in an incident, because ultimately we want to prevent those sorts of incidents from happening again. We want to get to the bottom of what's happened. We want to identify those systemic issues so that we can prevent future occurrence. And that becomes a much, much, much more difficult exercise when you're lawyering up from the beginning with multiple lawyers in the mix. So I take the view that that's not necessarily good for safety. And that's why I made that comment earlier, that I don't know that people are necessarily thinking about those negative consequences for safety outcomes that are posed by these particular developments. Because we're not going to get that information sharing for lessons learnt that really should be at the heart of what we're trying to do here when these incidents occur. So how we're dealing with those, that newfound focus on incident consequences becomes really important as well. So I wanted to talk a little bit about practical tips of what we do going forward. So this slide just gives you a bit of a sense of my top practical tips, but I'll talk through a couple of others as well. I think there's a real need for organisations to update their incident investigation protocols to specifically include fatality protocols, because what you're going to need to do in the event of a fatality is different to other kinds of serious incidents. I haven't really seen that happening too much in the organisational incident notification and response protocols so far, and that would be one of the top items I would be suggesting going forward. You really need to take a proactive approach to understanding the various powers of the various regulators and enforcement agencies that are going to get involved when it comes to a fatality, and that's part of that process of updating the incident notification and investigation protocols for fatalities. So there are different powers, there are different functions when it comes to police and health and safety regulators. Are we actually adapting to those different approaches as relevant? And linked to that is this idea that you really need to establish a legal panel for representation of multiple interests, given that we are going to have those conflicts of interest starting to emerge between individuals and companies and multiple companies as well. We really need to have all of those interests being represented right from the beginning if we're going to protect our workers from these sorts of prosecutions. And then you might want to think about having protocols between the lawyers on those panels in terms of how they will engage with each other in information sharing and communication, notwithstanding those conflict issues, and dealing with all of that together. So having a bit of an approach to how that's going to be coordinated when or if any such incident occurs will be important. You want to brief officers on the developments in refresher due diligence sessions. So as we all know, the officer due diligence obligation requires officers to acquire work health and safety knowledge and keep that knowledge updated over time. If it's been over 12 months since your officers have received a due diligence briefing, you really want to get them one that's picking up all of this material and talking about the practical tips for how they should be responding. And in that as well, one of the things that I like to talk about is that there's a real need to treat improvement notices and prohibition notices more seriously than we may have been treating them to date. So given that a lot of the sort of focus is on what people are talking about as repeat offenders, and also given the way in which regulators are using improvement notices and prohibition notices as evidence in prosecution proceedings of previous conduct, as well as evidence of what people are doing to post-incident, and using that as the reasonably practicable measures for controls that could have been in place pre-incident. There's a real need for us to to treat notices more seriously when they land. And I do think officers need to have an oversight about that, because it's not just dealing with the notice. There's a world of future liability and future enforcement action that seems to be coming off the back of those notices and how regulators are working with them. So if you have a repeat of the type of situation in one improvement or prohibition notice somewhere that's, you know, at a lower level, but then you have the significant consequence fatality in relation to that same hazard or risk that was subject to previous improvement or prohibition notice, you're in a higher risk zone, shall I say, in relation to potential prosecution. So you need to see these things as sort of early warning signs for your system and get more proactive about them. It's not just about closing out that individual notice. It's about making sure we've actually properly closed out on whatever that hazard or risk category is, as it relates to all of our operations more broadly. And I think that's something that officers really need to know about in terms of the due diligence briefings as well. The other thing I would say is update the incident response training and include that in emergency drills as well. One of the lessons indeed that we saw from Dreamworld was the real need to ensure that we've got system preparedness and readiness of not just the system but individuals in terms of leadership in how you respond to a serious incident. And when we are talking about fatalities, we're talking about that significant consequence type of space. So, and community expectations are such now that we have to make sure that we've got really robust systems and they're going to actively be implemented. So once we've updated those incident investigation protocols for fatalities, making sure that we've got training for people in understanding what their role is at various levels in making sure those fatal risk protocols are actually adopted when something catastrophic happens, if it does happen, and also making sure that we've tested that. So a lot of our emergency drill types of approaches seem to be, you know, just do an evacuation of the building. I think it's much more useful and powerful for learning lessons outside of a tragic consequence type event if we can start drilling that entire approach in how we will manage it, including your legal panels as well, and all of those people that you're going to bring to the fore to make sure that coordination approach is going to work in the way you intend it. There's nothing worse than only doing that once the tragic event has occurred, because you don't want to learn your lessons when you're trying to deal with something of that kind of magnitude. I would also recommend that people get involved in the regulatory impact process that will be happening with Safe Work Australia. Get involved in stakeholder engagement. If you have particular views about these things, share them, because there's still a capacity, I think, for us to influence what these industrial manslaughter offences look like if and when they are introduced within the harmonised WHS laws regime process. But ultimately, I think the best approach you can possibly take to legal liability for these significant consequences that can occur here in relation to industrial manslaughter is very much don't have a serious incident, don't have a fatality. That's your best legal liability strategy. Don't have the fatality. So how do we actually avoid having these fatalities? It's about taking that proactive safety risk management approach and really investing in critical WHS risk controls and making sure that we understand what that is. The other key tip I would have for you is make sure that you're investigating your serious near-miss events, because they really are giving you early warning signs for the potentially catastrophic event that could be around the corner. And one thing I know from the hundreds of incident investigations that I've done in my practice is that pretty much in nearly every single one, we find that there are multiple serious near-miss catastrophic consequence potential events that occurred prior to the incident that resulted in the death or serious injury. So take those more seriously, investigate them properly, and you will potentially avoid that catastrophic event. And that's what's good for safety, but it's also what's good for looking after the legal liability piece here. And with that, that's all I really wanted to say to you. So any questions, please, we can have a talk about those now. I have also put on the slide here Michael Toomer's due diligence series. He goes into a bit of detail about best practice approaches to things like incident notification, management and investigation, and dealing with regulators in a couple of those books. It's now in its second edition, so I would recommend you read those. I get no royalties from saying these things, guys. I just think they're really great practical books for these sorts of purposes. So check that out. It's through CCH. Now, do we have questions?
We only have one so far, Elena, from an anonymous attendee. Our head office is in South Australia, but we have employees in Queensland. Would we be prosecuted under South Australia legislation or Queensland?
Thanks for the question. It depends where the incident occurs. So if the incident occurs in Queensland, you're talking about prosecution under Queensland laws. If the incident occurs in South Australia, it would be prosecution potential under South Australian laws. Now, if you are a Commonwealth agency, it would be prosecutions under Commonwealth legislation.
Okay.
But if you're looking for a more specific for your context, please feel free to send me an email.
All right. Amy asks, do you see the scope extend into serious injury, not just death? As the result of a serious incident resulting in incapacity suggests there are more issues in the long term than a death.
Yeah, I think if the Boland Review recommendations something to go by, recklessness or gross negligence for serious injury or illness, as well as death, would all be part of the Category 1 offence. So yes, there could be the potential for that to be taken, or, you know, equally, we could end up seeing a different type of category of offence coming up. To be honest, we just don't know yet.
Okay. Well, we don't have any more questions unless one pops up in the next 5 seconds. So I would like to remind everyone that we will send a recording. We'll also send with the email a link to some contact for Elena for any further questions. And a reminder that Elena will be speaking at the Safety Skate Conference in Sydney on the 21st to the 23rd of May at the International Convention Centre. Oh, just one moment, Elena. There's a few questions coming through on the chat panel. Yeah, I thought there might. Wayne asks, how does an entity fit within proposed prosecution as an entity is not a person?
Yeah, so those industrial manslaughter reforms in Queensland, just to take the Queensland example for now, it's for organisations as well as individuals.
Okay, and from Rosanna, in what way would a fatality protocol differ from a more general one?
Look, there's a number of things that I would want to be doing, but essentially it's about doing that lawyering up piece is a big part of that process of making sure that everyone who is potentially in the chain of what's involved actually has access to legal representation to look after their rights and powers. I think it's also important for people to understand the difference of the rights, powers and functions of health and safety regulators as well as the police. You know, whether you do or don't talk to various people, and there are, you know, legal requirements to talk to safety regulators, whereas you don't have to talk to police, as just one example of some of the things that you want to cover in those. But fatal risk protocols is essentially about getting, the second the fatality happens, you have to marshal the troops straight away in order for those interests to be protected.
Okay, Mark asks, can you foresee a clash between reckless endangerment and various employer duty section breaches?
I think, yeah, I mean, that's very much a Victorian kind of approach. And we're now seeing the industrial manslaughter offence potential in Victoria. It's quite interesting to me to see how that's going to play out with the Section 32 reckless endangerment provision. And again, I think it's too early to tell exactly what that's going to look like because we haven't seen the detail in the Victorian proposal in relation to that issue.
Okay, and Ian asks, how will this affect the mining industry?
Very, very good question. Again, I'm not sure that we have a full level of detail around the country in relation to the mining industry. Interestingly, Queensland carved out the mining industry in relation to the industrial manslaughter offences. I don't know that that's an approach that we will see going forward. I think the general feeling is that it should be something that is captured for all industries.
Okay, Wayne said, is there a proposal to define what constitutes an officer or senior officer within the current plethora of corporate and organisational definitions, and what capacity does the judicial system have to address these proposed laws?
All right, so in terms of the officer definition, it is defined in the WHS laws. So it says an officer takes the definition under Section 9 of the Corporations Act. So it just wholly bolus takes the Section 9 officer definition, and there's multiple parts of what that is, and different for different types of organisational contexts as well. So that is defined, but the difficulty is those subsections of the officer definition that I was talking about in the discussion. An officer is a person who makes or participates in making decisions that affect the whole or a substantial part of the business of the corporation. So what is the whole? What is a substantial part? What is making a decision? What is participating in making decisions? That's where your courts get into the territory of interpretation. And we've seen that interpretation, particularly in relation to corporations law, and there's a couple of cases that really get into what those things mean. And in fact, I'm trying to remember, I think it was SafeWork Australia that put out an interpretive guideline on the meaning of officer. And it's an interpretive guideline, it doesn't have status of law, but if you're interested in reading basically a summary of what the courts have had to say in that regard, the SafeWork Australia interpretive guideline on the meaning of officer is a good start for you.
Okay, Amy asks, if the legislation becomes harmonised, will the improvement notices, etc., from various states and territories be used for a prosecution? That is, if a fatality occurs in Queensland, will notices from other states be utilised as evidence?
It's a really good question. The different regulators do have memoranda of understanding about the sharing of information. I think there are things that you can do when you have a good lawyer, such as myself, around whether that is used in evidence. So, you know, talk to us. Those are the sorts of ways in which lawyers can be helpful.
Okay. John,
not always helpful, but it's helpful there.
John asks, is it possible that a volunteer could be deemed an officer?
Sorry, could you repeat that question?
Is it possible that a volunteer could be deemed an officer?
Yeah, so absolutely, you can have volunteer officers, but there are particular exemptions around the taking of prosecution proceedings against volunteer officers, and there's particular exemptions in the current drafting of the legislation in that respect. That's not to say that volunteer officers don't have the duties, it's just that prosecution proceedings won't result. And the whole idea behind that was we don't want to stop people from participating in that fabulous way in society at large. So we want to encourage volunteer support in that respect. And so that's why you've got that exemption. Now, it's a really good question about how that's going to play out in relation to the industrial manslaughter offences, and whether there would be a similar kind of exemption for anything fitting into a Category 1 offence. But if you're talking about recklessness or gross negligence, potentially we won't see that same exemption, because you're talking about a particularly egregious kind of conduct here.
Okay. Anonymous asks, so does the mining legislation treat industrial manslaughter differently to WHS in Queensland?
Yeah. And I'm happy to talk to that person offline who's interested in the mining piece.
Okay. All right. Finally, Anna asks, can branch managers be deemed officers?
Can branch managers be deemed officers? It depends on your organisational governance structures. So if your branch managers are people who could be considered to be persons who make or participate in making decisions that affect the whole or a substantial part of your undertaking, then yes, they could be officers. It just depends on how you've organised your decision making in that respect.
Okay, well, our timing is quite perfect. There's just two more little comments, but they're not questions. Dennis has said, brilliant as usual, and thank you. And
thank you.
And Diana said also, thank you. That was very interesting. So as I said, we'll include email information for Elena, and if you have more questions for her or the company, Clyde & Co, that will be, you can send them. So Elena, thank you very much, and want to wish everyone a really good break, which should be happening in a few hours. And yeah, so thank you for joining us today. Really appreciate it.